Gov and Law 1.2 Major Principles of the Constitution, as well as arguments for and against ratification of the Constitution. Before we get into the major principles or themes, as well as ratification, I would like to clarify a few terms that are somewhat confusing to people. The first term we should look at is the term federation. A federation is a formation of a political unit where each part retains its sovereignty or own independence. The United States was under the Articles of Confederation under their first national government. Most of the power was retained by the states, which made the central or national government extremely weak. Federation is a loose group of states, somewhat similar to the Confederate States of America during the Civil War, the South. Federation is very different from the term federal government. Federal government is when the power is divided between the central governing body, in our country that's in Washington, D.C., and smaller political units, such as states. We have 50 states, and then we have many smaller political units. From there, we have all sorts of counties, townships, cities, villages, etc. The federal government, an example here, is that you pay national, state, and local taxes. So you pay money to all three groups of people. You pay federal income tax, you pay state income tax, or maybe you pay a state licensing fee if you go hunting, and you also pay local sales tax, whether that's in Byron, Rochester, or wherever. Another term is the national government. The national government is often interchangeable for federal government, but they actually mean two very different things. Federal government divides the power between two or more groups of bodies, whereas the national government is where the central authority is. In our country, that's D.C. The central authority has representatives from each of the smaller 50 political units, or the states. So the national government is strictly the federal or D.C. government. We typically call them the federal government, but actually should be called a national government. Hopefully these terms are now a little bit more clear to you as we go through the rest of the quarter. You'll be able to understand the distinction when people say federal or national government, as those terms are often used interchangeably. So let's talk about major principles or themes of the United States Constitution. Remember, a principle or a theme is the subject of a piece of writing or a document or something, or a particular setting of a film, etc. A theme or major idea behind the summer of 2013 is that Americans are obsessed with the White House being attacked, considering that there were two major movies, White House Down and Olympus Has Fallen, with basically the same exact plot that were released and made millions and millions of dollars, telling you that Americans really like the theme of the White House potentially being attacked, but saved by some rogue agent. The themes of the Constitution are in no particular order, but one of the first major themes, something that's very inherent in the entire Constitution, is the idea of popular sovereignty. So popular refers to population, or what's popular, what's cool or trendy, or what the population wants. And sovereignty, of course, relates to independence. So popular sovereignty is the rule by the people. The government is based on the consent of the governed. Authority flows from the people. This was based, of course, on the ideas of John Locke, that English philosopher who lived back in the 1600s, who established the social contract. Everywhere in the Constitution, it talks about how the people have the power, and the people have the power to elect officials, the people have the power to impeach, the people have the power to review the laws, the people, the people, the people. So, popular sovereignty is a very clear and obvious theme throughout the entire Constitution. All 7 articles refer to it in some way, shape, or form. Federalism is yet another theme of the United States Constitution. It is a difficult theme to understand. The entire next video is dedicated to understanding federalism and how it works in the United States. Federalism, a basic definition, is that the power is divided between the national and state governments. An example here is the fact that the national government passed NCLB. NCLB stands for No Child Left Behind. That's the U.S. Department of Education's policy that no child should be left behind in the United States. Therefore, every single state should meet certain standards by a certain time period in order to prove that every child, regardless if they're black, white, Hispanic, or live in a rural or urban area, is being educated the same way. However, federalism applies here because as the federal government passed No Child Left Behind, each state got their own independence in deciding how they would meet No Child Left Behind. In Minnesota, we have the MCAs. You take the reading test, the writing test, science test, etc., to determine whether or not you're meeting certain standards as set by the federal government. So we use standardized testing. Other states use other forms of standardized testing at different grade levels, and other states use project-based assessments or other options. So this is an example of federalism in action. Both have power, both the national government and the state government have power over education, but each has power in very different ways, so they're sharing power. Another major theme of the United States Constitution is this idea of separation of powers. So you know that we have 3 branches of government. The power is divided among the branches of the government because the belief is that the most effective government has divided duties, that each person should have their certain job or role in doing what's best for the entire country. So this takes into account comparative advantage, which is a term that we went through in economics. So we have 3 branches of government. We have the executive branch, the legislative branch, and the judicial branch. So in looking at them like a tree, thinking about them using the analogy of a tree, each is tied to the single trunk of the U.S. government, but each has a very different function on their very own branch, and the branches don't intertwine with one another. So in reference to thinking about laws, which is very important in our country, of course, the legislative branch has the power to create the laws. That's Congress. That would be the House and the Senate. So they actually create and write the laws and pass them. The executive branch has the power to enforce the laws. The executive branch is the president, and he has the power to make sure that laws are enforced. For example, Dwight Eisenhower had to send the troops into Little Rock, Arkansas to make sure that desegregation was allowed in the Little Rock schools. The judicial branch then has the power to review or interpret those laws for their viability or constitutionality. Most of that is done through the Supreme Court, but it is done in the lower courts as well. So, for example, the Brown versus Board of Education case, which determined that segregation is illegal under the Constitution of the United States, was part of a review by the judicial branch in looking at desegregation laws. Separation of powers is very clear in the fact that we have 3 very distinct articles, one dedicated to each of the branches in outlining their duties and the limits of each. Speaking of the limits of each, inherent in our Constitution, or a major theme, is the system of checks and balances. Each branch, each of the 3 branches, exercises some control over the other branches. If you think about it in reference to a candy bar, it's like sharing a candy bar. One has the power to divide the candy bar, but the other person decides who gets which piece of the division. They both have power, but their powers are very distinct and very different. If you were forced to share a candy bar with your little brother and you got the power to divide it, you'd probably give the bigger piece to yourself. However, the system of checks and balances said that whoever divides it does not get to decide who gets which piece. That indeed gives both branches, or even 3 branches in this case, power. An example here is the president. The president is commander-in-chief of all armed forces, but only Congress can authorize the use and funding of the military. So that puts a checks and balances in place and keeps us from having the president take out personal vendettas against other people and sending our military all over the world. Another theme running through the United States Constitution, which had to be clarified in Marbury versus Madison, is judicial review. Judicial review is the idea that the court limits the action of the government that does not comply with the Constitution. Sometimes Congress passes laws which are unconstitutional. So it is up to the Supreme Court or the judges to practice judicial review in order to make sure that each law complies with the Constitution. An example here is flag burning. Congress could pass a law declaring it illegal. However, the Supreme Court would strike down the law as flag burning is a protected form of speech under the First Amendment rights. This was established in the 1989 case of Texas versus Johnson. Here we have Johnson, who famously burned a U.S. flag in Texas. Texas brought a court case against him because it was illegal in Texas to burn an American flag. Well, the Supreme Court looked at that and decided that yes, indeed, you can burn an American flag because it is a form of symbolic speech as protected under your First Amendment rights of the United States Constitution. That does not mean that flag burning isn't necessarily wrong in the eyes of most Americans. However, it is legal and no law can be passed declaring it illegal. Another major theme running through the United States Constitution is the idea of limited government. The Constitution limits government by specifically listing the things that it can and cannot do. For example, who has the power to declare war? Who has the power to coin money? So basically, it's a giant list of what the government can do, and anything not listed is a right retained by the people. That right retained by the people is clarified in the Ninth Amendment, part of the Bill of Rights, which we'll get to in the next unit. But this Constitution specifically lists the rights and freedoms of its people and ensures that the government does not abuse its power by limiting or writing down what the government actually does. So the entire Constitution itself, every written word, limits government in the fact that it outlines what government can specifically do. Now that you've learned about the 6 major principles or themes of the United States Constitution, try to come up with your own original example for each, as we'll need those for class tomorrow. Let's briefly look at the best parts of the U.S. Constitution. You can argue that the entire U.S. Constitution is fabulous, as it's one of the longest living written documents or forms of government in world history. However, there are some parts that most constitutional historians consider the best quote-unquote parts. One of the best parts is the Elastic Clause. It's in Article 1, Section 8, line 18, which says that Congress can make laws necessary and proper for carrying out foregoing powers. What that actually means, or if we translate that, is that Congress can make any law necessary to carrying out their duties. We call this the Elastic Clause because it allows the Constitution to bend and stretch like elastic. This Elastic Clause is used to create all sorts of federal agencies, such as the Federal Reserve, the Environmental Protection Agency, Department of Homeland Security, etc. The Elastic Clause allows Congress to do all sorts of things that aren't necessarily written in the Constitution, but are needed by an evolving government 200 years after its making. Because the Founding Fathers had no idea that we would need something like the Environmental Protection Agency or the Federal Communications Commission to regulate what's on TV, because obviously it was the 1700s, and they didn't have that. So the Elastic Clause allows Congress to do a lot of things that they wouldn't otherwise be able to do if this clause wasn't necessarily in there. The second best part, quote-unquote, of the Constitution is that the Constitution is the supreme law of the land. The Supremacy Clause is outlined in Article 6 of the Constitution in both Clauses 1, but more specifically in Clause 2. It says that the Constitution is the supreme law of the land. No law can be above it. So, for example, a state can't pass a law saying that they're going to have a government that can supersede or go above the United States government. Also, the Supremacy Clause of the Constitution means that laws passed under the Constitution cannot be above them, which leads us into a difficult situation when the states start doing things that are outlawed by the federal government, such as legalizing marijuana, which will become a hot topic in the next 10 to 20 years. Once the Constitution was written by the 55 Founding Fathers, it needed to be ratified. In the Constitution, in Article 7, it says that 9 of 13 states are required to ratify the Constitution. If we think about ratification needed to occur at the district level. So within the states, each state legislature had to approve the Constitution. As you can see from the map, each state was not solidly for or against the United States Constitution. There were groups or pockets of people all across the country who were either for or against the Constitution. In Virginia, specifically, there were very small segments that are marked in green where there was a tie. Most of the state, physically, was against the Constitution. However, those areas were sparsely populated. Those areas that are more heavily populated, specifically in the Richmond area, were more for the United States Constitution. So ratification was not a simple thing. Delaware was the first state in the nation to ratify the Constitution, and New Hampshire became the 9th. In order to get the Constitution ratified, there was a very strong fight between Americans. Those people who were strongly for the Constitution being ratified were known as Federalists. They were for a very strong national government, for a strong checks and balances system, and they believed that the Union, or the nation, would do a better job than the Articles of Confederation in guarding against any kind of trade dispute or any dispute with other countries. One of the most famous Federalists is James Madison. He very famously wrote a series of what's called the Federalist Papers that showed him to be a brilliant political thinker and a writer that would convince many people to vote for the ratification of the Constitution. On the flip side were the Anti-Federalists. They were people who didn't attend the United States Constitutional Convention, but they feared that the Constitution took away states' rights and the rights of the individuals. They wanted more of a confederation system. They wanted a specific list of the rights of the people. If the rights were not listed, they believed maybe they didn't exist. Although the Anti-Federalists were at a disadvantage in the fact that they weren't at the Constitutional Convention, and largely they were made up of farmers and rural people who did not have access to the writing materials, the funds, or the printing process, they did advocate strong enough to get the Bill of Rights, the first 10 amendments of the Constitution, added in order for ratification to occur. Because the Bill of Rights were in for all intensive purposes, the Constitution by the time it was ratified or put into place finally in 1791. We'll deal more with the Bill of Rights in the next unit.